wider context of financial crimes, the implications of the Bribery Act, but obviously specifically the issue. As you know, we're looking into the wider context of financial crimes, the implications of the Bribery Act, but obviously specifically the issue of the Tanzanian contract for air traffic control system. I wonder, first of all, though, if you could introduce yourselves for the record.
Thank you, Chairman. My name is Bob Keane. I'm the Head of Government Relations for BAE Systems.
My name is Philip Hamill. I'm the Group General Counsel of BAE Systems.
I'm Simon Cairns, Lord Cairns. I have taken on the role as the Chairman of the Independent Committee to advise on the distribution of the funds at question.
Okay, well, if we can start by saying that BAE is a British company which pleaded guilty to an offence in the UK relating to improper record keeping or improper accounting. Can you explain why this should result in what appear to be reparations of £29.5 million being paid, quotes, for the benefit of the people of Tanzania, and indeed what calculation was made to establish the loss the people of Tanzania suffer as a result of what appears to be just a bookkeeping offence?
On the basis of the settlement that we reached with the Serious Fraud Office, the company considered it, in discussion with the SFO, appropriate to make a payment to the benefit of the people of Tanzania, based on the fact that the settlement referred to an offence which related to a contract in Tanzania. The quantum was discussed in negotiations with the Serious Fraud Office. Perhaps I'll ask Mr. Bramwell to say a word about the quantum.
Yes, the quantum from the company's perspective bore no relation to the value of the contract in Tanzania, which in the economics at the time was around £24.5 million, but instead to the investigation which had been going on for some time by the SFO, the quantum of the US settlement, the differential factual circumstances underpinning the US settlement on the one hand and the UK settlement on the other. So the amount of 30 million was arrived at by reference to being a component part of a global settlement of investigations on both sides of the Atlantic. The second issue of how that money should be applied was a separate issue. There was no consideration given to reparation to any one group of people, and particularly not in relation to this contract.
Well, Mr. Justice Bean said he was, quotes, astonished at the claims made by BAE that they were not corrupt. He said it was naive in the extreme to believe that.
Mr. Justice Bean chose to draw an inference from the evidence put before him, which was not invited by the Serious Fraud Office, and certainly with which the company does not agree.
Well, that, of course, is because it was a plea bargain, was it not? That you plead guilty to a lesser charge because you've got an agreement with the SFO?
No, I don't think it was a plea bargain in that sense. It was a settlement which reflected the facts available and the evidence available to the Serious Fraud Office and the company.
So in response to a simple bookkeeping error, British Aerospace in its magnanimity decided to give £29.5 million pounds to the people of Tanzania?
No, I don't think I would characterise it that way. I would instead say that, and I should say it's not British Aerospace, that company ceased to exist in 2000. BAE Systems, as part of a global settlement with both the SFO and the DOJ, paid an amount of £30 million to the Serious Fraud Office, or was willing to do so. The issue then arose as to whether or not the best use of those funds was to go to the UK Treasury or to be applied elsewhere.
Well, we'll come back to that.
Yes.
Bring in Hugh Haley.
Was the decision to via part of the penalty from the form of a fine to payment to benefit the people of Tanzania first proposed by the Serious Fraud Office or by your company?
Well, we've tried hard to recollect in a long, complex negotiation who first suggested that. And I think, on balance, we cannot be certain whether it was proposed by the SFO or initially by the company in the middle of that negotiation. Suffice it to say, and I think all I can usefully say, is that we agreed that that seemed like a good thing to do.
It's clear, nevertheless, that the company made the offer in order to, as a mitigating factor, in order to reduce the size of the fine that was going to be imposed on your company.
No, actually, that was not the intent.
With great respect, it's what the director of the SFO and and your company jointly said in the joint sentencing submissions. So perhaps you should remind yourself of what you said at that time.
Well, my recollection when I was present at the negotiations was that it was a settlement amount that we were paying to the SFO. What we could not do was prejudge or in any way fetter the sentencing discretion of the court. We were aware of other settlement discussions that had gone on, and we were anxious to make sure that we had an amount of money which was paid by way of settlement from which a fine would be assessed. And until such time as the court was able to assess that fine...
I think, if I may interrupt you, you're dissembling.
I'm so sorry.
In this document, which your company has put its name to, it's a joint sentencing submission, under the heading mitigating features, it says the company has agreed to make a voluntary payment for the benefit of the people of Tanzania. At the time you were in front of a judge in the court, you accepted that the payment was intended to be a mitigating factor.
I think if you're referring now to the transcript of the hearing or the joint sentencing submission to the Crown Court...
No, I'm talking about the sentencing submission itself.
The sentencing submission. What was actually said in court, and if that's what it says there plainly, I don't disassociate myself from that. What was said in court subsequently by leading counsel on behalf of the company in mitigation was that the company sought, through making this payment, to have an opportunity to restore its reputation.
Could I ask why your company paid Mr. Vithlani 31% of the contract price?
That was our contractual obligation, having acquired Siemens Plessey Radar Company in 1998. The overall level of commission was actually reduced, but it was an inherited...
It was reduced to 31%,
yes.
Wasn't it? So
yes.
The 31% figure is accurate.
Yes, it is.
It was reduced from 40% to 31%.
Yes.
Yeah. What were you buying with a sum of, was it £12 million? Can you remind the committee what...
Ultimately, it was 12 million, yes.
Yes. What were you buying with that money?
Complete in-country marketing representation.
It says here, in the submission the director of the SFO made to the court, that the contract was for the provision of various services as required by your company with regard to activities in Tanzania, including, if required, advice on financial and commercial aspects of doing such business. Is it normal to pay a £12 million commission for representation in a foreign country?
I think that would depend on the length of the programme and whether or not a company would have, at that time, have had a representation. Certainly not something the company would do today.
It says here that British Aerospace accepted, as part of your plea, that, and I quote, there was a high probability that part of the $12.4 million would be used in the negotiation process to favour British Aerospace Defence Systems Limited. What does that phrase mean, to favour?
To promote, to lobby, and to do all that could be done in a competitive process to secure the contract for British Aerospace as it then was.
And did the lobbying include payments being made to third parties?
It did not.
So what did Mr. Vithlani use the $12.4 million for?
Well, as we've said in the company's most recent submission of evidence, Mr. Vithlani received no retainer of any description he alone assumed the risk of representing the company for a long period of time, 7 years without payment at all of any commission. I don't think the company would today invest that much risk in any one individual.
Will you be allowed to with the Bribery Act?
I don't think the Bribery Act itself will prohibit it, but the company's own procedures would say that paying that level of commission is not something that we as a company believe you could responsibly do in this day and age.
I mean, Mr. Justice Bean said that it was naive in the extreme to think that Mr. Vithlani was simply a well-paid lobbyist, and he said there was a high probability that part of the $12.4 million would be used in the negotiation process to favour BAEDS.
Mm-hmm.
What does that mean, used in the negotiation process to favour?
Well, I think I can only refer you to the SFO's own case, and I know Mr. Alderman's appearing before you, but the SFO was very clear before the court that it was no part of its case that any corrupt payments had been made in connection with this contract. After 5 years of investigation, that was its factual conclusion.
That was the SFO's case, but the judge didn't accept that.
Well, again, I would say the judge chose to draw an inference at the time, which was no part of the SFO's case, and which the company does not accept. There was 5 years of investigation of this contract. The company provided, as we said in our evidence, many thousands of pages of documents in support, and that was the conclusion of the SFO.
Right. Richard Burton, then, sorry.
Do you require Mr. Vithlani to provide you with about where this money went?
We required Mr. Vithlani to enter into a contract which had, amongst other things, provisions making clear as to what his role was in support of the marketing activities of the company and representation over the 7-year period prior to the contract and the 12-year totality of his representation, and which had explicit business conduct requirements in prohibiting the payment of bribes in any way.
Is Mr. Vithlani being investigated by the Tanzanian authorities?
I'm afraid we have no way of knowing that. It's a question you would need to direct to the Tanzanian authorities.
Finally, I wanted to ask what measures British Aerospace has put in place to prevent a repetition of this kind of event.
Well, thank you for that question. We have summarised in our first tranche of evidence the steps that we have taken over the past 4 years in the most recent refresh of the company's policies. In 2007, we instituted a new global code of conduct, and we, at that time, terminated all of our existing international marketing advisor arrangements so as to, as it were, reset them in accordance with new standards and new commercial terms. Shortly thereafter, we commissioned Lord Wolfe and a committee of experts to produce a report for the company on what steps it could take to ensure that the company achieved its aspiration of becoming recognised as a leader in business conduct. The committee reported the following year, May 2008, and made 23 recommendations which the company had a year before committed itself to implement in full, irrespective of what they were. The committee also recommended that 3 years on from the publication of its report, the company get an independent assessment of the extent to which the company had succeeded in implementing the 23 recommendations in full. That report was done by a company called the Ethical Leadership Group in Washington, D.C. It was a detailed an extensive review of the company's actions in the intervening 3 years since the Wolfe Report recommendations were made, and the Ethical Leadership Group's report, which is published on the company's website, confirms that the company has indeed implemented in full the 23 recommendations.
Perhaps I can just... Sorry, Chairman, can I just make one specific additional point, which is that in relation to Lord Wolfe's report, he does make some specific comments about the company's policies and processes towards the engagement of marketing advisors, and sets out the principles on which those engagements will be made, including some of the red flags, as the company describes it, which would prevent the engagement of advisors in the future.
Yes, my colleague Hugh Bailey quoted from paragraph 24 of the note for opening of the Crown Court, where it said there is high probability that part of the $12.4 million would be used in the negotiation process to favour British Aerospace Defence Systems Limited. However, it then goes on in paragraph 25. Accordingly, BAE has accepted there was a high probability that the payments to Vithlani were intended to compensate him for work done in seeking to persuade relevant persons to favour BAE DS in respect to the radar project. It is not now possible to establish what Vithlani did with the money which was paid to him. Does that paragraph just repeat the paragraph before, or was it saying something else?
I think it does re-emphasise what Mr. Bramwell has already said, which is our belief is that Mr. Vithlani was operating in Tanzania, seeking in the way that business development people do in every walk of life to persuade potential customers to acquire products and services from any particular company. So I think it was re-emphasising what Mr. Bramwell has already said.
You felt that Mr. Vithlani was operating a way that people would in any walk of life?
What I was suggesting was that, as Mr. Bramwell had said, he would be carrying out lobbying and other business development marketing activities in Tanzania. That's
Why is the word compensate used? Says, you know, and it follows on from the previous paragraph. It says high probability that payments to Vithlani were intended to compensate him for work done. Isn't that a strange?
Work done is entitlement to reward under a contract for services performed. I mean, that's
so
how I would
when you get your fee from the company, do you describe that as receiving compensation?
Yes. Yes. So in the reports of a public company, for example, there is a director's compensation report. That's
Could I just follow that up? If this was an entirely legitimate business activity, common in any jurisdiction, to use your words, why on earth was this mentioned in the opening submission to the court as something particular and worth noting, and which the judge ought to be aware of? Surely this was in the document to suggest that something improper might have been done with that money.
Well, I think it's an important fact associated with this contract and with the payment of Mr. Vithlani. The amount of money he was paid was, by reference to today's standards, extraordinary, and it's only right, therefore, that it should be brought before the court.
Thank you.
Attention.
I take that as a yes.
Can you tell us how the figure of £30 million for potential reparations was determined? You said it wasn't broadly equivalent to the value of the contract to supply the air traffic systems. So would you say the figure of £30 million relates to any estimate of the amount of overcharging on the contract?
No, the 30 million...
Where did 30 million come from?
It was a negotiated sum, actually by reference to the $400 million paid to the United States Department of Justice in connection with the settlement as well. So this was a wide-ranging negotiation about a global settlement and the relative facts addressed on either side of the Atlantic, because there were some overlaps in the US and UK investigations. And I think the SFO was anxious to avoid a sort of double jeopardy, double penalty situation, the company having settled on one set of facts, which included facts being investigated by the Department of Justice and therefore settled in Washington, D.C. And then on the UK side, the settlement therefore was covering different sets of facts, the ambit, the remaining ambit, as it were, of the SFO investigation. So from the company's perspective, that was how the number was arrived at during the settlement discussions.
And then earlier you said about paying it to the Treasury. You haven't paid it to anybody yet. The Treasury, the government of Tanzania, nobody.